Hi everyone, welcome and thank you for joining us. I'm Suzie Leask. I'm a director here at Australian Business Lawyers and Advisors in our corporate and commercial team. I'm really excited to be here. We have so much to talk about today, but before we start, I would like to acknowledge the Gadigal people of the Eora Nation, the traditional custodians on this land here in Sydney, where we are today, and pay our respects to elders past, present and emerging. And welcome also to Kurt Wicklund, my senior associate in our team here at ABLA. We have so much to discuss.
A lot to talk about today.
This is an incredibly massive time, I think, for businesses in the commercial space. We have regulatory changes like we've never seen before, some massive penalties, expanded laws as well, increasing regulation, not to mention, of course, last but not least, the cybersecurity issue that is all over the
Lots
headlines.
Of questions.
So, yeah, we've got lots of questions coming through about that as well. So we will have some time for questions at the end, so please do send your questions through. But let's get stuck into it because there is so much to cover. And I think, you know, we've been talking about this and it is an extraordinary time for businesses. And I don't think I've ever seen anything like this in my career in terms of the cost of business and the cost of regulatory compliance for businesses who are going about their operations in that commercial contracting environment, in the competition and consumer law space. So let's kick off with penalties. Let's start with what that's going to look like and in fact, what it looks like now.
Yeah, so we've just had some recent changes to the Competition and Consumer Act, and they've brought in these huge increases in potential damages across the entire suite of penalties in the CCA. So that's in both competition and in consumer law prohibitions. So we're talking about higher penalties for all your cartel conduct, misleading, deceptive conduct, but also across in things like franchising and codes of conduct. So
unfair contracts.
Unfair contracts. That's right. So we now have the previous penalty. We're looking at the greater of $10 million, or if the value cannot be obtained, 3 times the value of the breach conduct, or 10% of the annual turnover. Now, we now have $50 million as the...
So 5 times.
Yeah,
so
that's right.
Not just doubled, we've gone 5 times the current penalties.
We still have 3 times the value of the benefit obtained, but we now have a 30% of adjusted turnover during the breach turnover period, which is either 12 months or the longer period of how long the relevant conduct occurred. So, I mean, all of these have just brought it up in a massive way. We also have the changes to individual penalties as well, brought up to 2.5 million. Now, it's important to note that this isn't just individuals who are acting in their own way. We're talking about individuals who are potentially directors in companies, who are in the business. Misleading and deceptive conduct can be someone who works in
managers involved
exactly.
in the contravention.
So these are big risks and big changes.
And big financial penalties, but also that reputational damage piece, which I think businesses will often tell you when they're in that space of getting regulator scrutiny and investigation, that reputational damage of just being in the media in some of these areas.
And the ACCC are big to come out as soon as something happens. They're big to come out with the media release.
They do a great job of their PR to say they're investigating business, unfortunately. That's a purpose, I suppose, that they have to keep the markets fair, but it can be tough to navigate when you're just investigated, the allegations haven't been proven, but you're in the media.
That's right.
So we are going to walk through the different areas that we're talking about today. We're going to touch on the unfair contract law changes and walk through that, as well as a bit on the competition and consumer and what these penalties apply to. But when does it start?
That's right. So we've got the increase in penalties we're talking about across the entire Act apply now. So these are for as of the 10th. So this is conduct as of last week will be subject to these higher penalties, except for the unfair contract law changes. So these, we've got a year from the 10th of November until the new penalties will come in. So that's really a deadline. It's a deadline between now and then for businesses to take a look at this area and understand how that's going to affect their businesses. Because if you're waiting until next year, the time's already gone.
Yeah, I mean, this has to be top of agenda, I think, for businesses. And also, I think, keeping in mind, if we can just do a little refresher, unfair contract laws, as much as we say the new penalties and the expanded regime starts in 12 months' time, these laws apply now. So they're actually not new. we have unfair contract laws currently that apply to both consumers but also small business contracts, so that business-to-business standard form contract space. And this is the little refresher on the slide up there about what the current position is. So we're talking standard form contracts, so where you have those standard T&Cs on the back of a quote, or a contract where it's your template that a lawyer's produced perhaps for you, and there's no opportunity to negotiate or take it or leave it. At least one party has to be a small business. Currently, that's 20 staff or less, including casual. So just mind that, because that's changing, that's going up. And there's a contract price threshold as well, around that $300,000 mark, or $1 million if the term is more than 12 months. There's guidance in the Act, of course, and the case law that's come out around what is unfair, because I'm sure there's lots of businesses listening, thinking about their contracts, and everyone starts with their template, their standard terms of business. What on earth is unfair in that commercial business-to-business arrangement? And you might be the small business that's contracting with another small business, or another big business, or even an individual consumer. So this will apply to those scenarios. But we're talking about where you have a term in a contract that causes significant imbalance in the parties' rights and obligations, or where it's not reasonably necessary, that term, to protect your legitimate business interests, things that would cause detriment to a party if relied on. But we also look at the contract as a whole. So we do recognise, as part of this legislation, that businesses do have legitimate business interests to protect, and we look at the whole contract, not just an individual term.
So currently, if we have these unfair contract terms, what the outcome is that they're not enforceable. So we have, there's no prohibition or penalty that goes with that. It's void. You can't enforce the term of that contract. So, that goes into drafting a lot of these things. You go, we might want to use this in the circumstances. We'll put it in there as best practice, and then we can choose to enforce it in the future.
And so I think businesses have been taking that risk, a little bit, where they perhaps haven't been incentivised enough to look at their contracts from an unfair contracts perspective, because the only outcome, apart from the reputational damage of being in the media or having regulatory prosecution in the courts, is that your contract's void and unenforceable, and you have to go back and renegotiate them. But
this is all changing. So not all of it, but if we just click through, we can see that everything in red is changing. So we're not just going to be dealing with small businesses. So we'll go into this in detail, so I won't jump ahead.
Let's walk through that.
Yeah, that's right. We've got a whole raft of changes to run through. Now, one of the big changes is really the eligibility threshold. We say small and medium businesses, but this is any business that employs fewer than 100 people or has less than $10 million in turnover.
How many businesses in Australia is that? We were debating this before. We've read statistics elsewhere that it's potentially 99% of businesses in Australia that this is going to cover.
And even the big businesses and the large entities that are on this webcast, I mean, you're going to be dealing with smaller entities, and you're going to be dealing with small companies.
Or medium-sized companies.
Medium-sized, that's right. So these unfair contract laws will now apply to any of those contracts entered into with those entities.
And the $0 threshold as well, I think, is interesting. So no longer can you say, I deal with the big end of town. I'm in a big mining company. I sell really, really high value equipment that gets over that $300,000 or that $1 million threshold. That's gone. So it'll apply to all of those standard form contracts.
So just as a reminder, this applies to the supply of any goods and services, or to one of the questions, a sale or grant of interest in land. That hasn't changed, but that still applies. And there's equivalent changes to the ASIC Act around the supply of financial services or financial products.
Yeah, and so it's applying to more businesses. That upfront price is going. And then one of the other key things is that clarity, or we hope it's going to be clarified, that's debatable, over what is a standard form contract. So what types of contract does this apply to?
So originally this is intended to apply, your standard T's and C's you put in and you say, well, this is it. This is what we sign. However, we've got some exclusions here now that, it could still be a standard form contract if they're minor or insubstantial changes. It still could be standard form if you've got, some negotiation within some boundaries that, your golden rules of the company. If this is, you set out exactly what you can agree to, still could be standard form. And even if there's a side letter or you have standard form and then we have kind of a separate contract to capture certain things, the original one will still be a standard form. So we really have that expansion of how this could impact.
And it's intended to capture more, right? Like when you look at these changes, it's not just the strictly standard form contracts that you have no negotiation rights over anymore. It is going to capture some of that wriggle room around the outside that maybe people had, offered to negotiate with you a little bit, change one clause, and it's not standard form anymore.
Exactly.
So that's going to change, and I think a lot of businesses are going to be affected by that. So financial penalties apply. So these new massive $50 million, 3 times the benefit, or 30% of that adjusted turnover.
And this is a big change. This is where no longer is it just void. You're going to be penalised for entering into one of these contracts or applying or relying on it. So no longer is it something that you could use maybe in the future. If you're entering into these contracts, there is the potential to receive up to $50 million in a fine, which is, which imposes a significant cost burden and a burden on businesses doing business on a standard form basis.
Well, I mean, that can put a business under, right, into insolvency.
Well, I mean, even just if you have your in-house legal team has looked at your documents and you're using these on a daily basis, this makes it really difficult to be able to for businesses to run their commercial managers and their frontline staff.
And I think those prohibitions as well that now make it unlawful to enter into, that's going to change the way people negotiate, because I think previously people put clauses in contracts that were nice to have. We never use that clause, we don't actually enforce it. Now it's just unlawful for being in there, even if you never apply it. And also that final point on the slide, the fact that the courts will be able to make orders, to not just make orders about the contract between you and me, but also about my other contracts with all the other businesses that I might have in place, and prevent you using that term in future contracts, which is, a huge reach.
Yeah, that's right. I mean, this is the same or similar, substantially similar term. There can be orders to say that you can't use this in your business in the future. And I mean, we could be talking about thousands of contracts, and some of the case law plays out. We're talking about thousands and thousands of contracts that could be at risk here. Now, we'll say these, of course, will only apply to new contracts, variations, or renewals. However, that still, potentially is a large capture of the suite of contracts.
Yeah, and we were talking about that a little bit pre-camera, about the fact that if you have those auto rollover clauses, then you might be getting caught because you've technically got a renewal contract, which is interesting. Let's talk a little bit about what's unfair, because I think this is the hardest thing for businesses to get their head around.
And not just businesses, lawyers as well.
Yeah, it's grey, right? There's no single rule. There's no, as much as the legislation goes through the types of things that might be considered unfair, the fact that we think about a contract as a whole, the terms, is it legitimate business interests being protected? There's not an easy checkbox little checklist to go, I can't have this clause in my contract anymore. Do you want to run us through that section 25, those examples in the legislation about unfair terms?
Yeah, that's right. So we have that test, and just as a reminder before, we've got that significant imbalance. That's really one of the key things. We've got whether it's reasonably necessary or cause detriment. But the legislation then goes on to say and give examples of, without limiting that test, what it would consider to be could be an unfair term. So I've got a few of those up on the screen, but we've got, there's 14 in all. And what's really interesting is we're talking about that imbalance, so giving one party, strong rights that aren't given to the other party. So, when we're looking at these as lawyers and in your in-house legal teams, you're looking at how that power relationship works within the contract in the context of the whole contract.
And that's so common, right? You draft a contract for a business, you want to protect your interests, and you make it a little bit on your side. You make things that are to protect your interests and in your favour.
Yeah, that's right. So, it's good to kind of look at legislation, but I think it's really, if we look at a recent case, now this is an example. This was by consent. I will say that this isn't a contested case. So Fuji Film got us some hot water, and it really represents the high watermark recently for unfair contract terms. Now, these unfair terms that we've got up on the screen, you see them every day.
Right, they're in every contract.
These are in significant numbers of contracts that come across our desks, and I would expect everyone to be familiar with these. So the federal court found that 38 contract terms used in contracts with Fujifilm were unfair, and some of the unfair terms included automatic renewals, termination rights, giving one party not the other, giving Fujifilm termination rights, limiting the liability of Fujifilm and termination payments, payment term differences, and then variation to those contracts with unilaterally.
Mm-hmm.
So Fujifilm admitted these were unfair under the current legislation and consented some declarations around using those terms in their current contracts.
Yeah, and look, like you say, I think those terms are in a lot of contracts, and I think businesses now have to revisit how they are doing business and how they're contracting, because they're going to end up, unfortunately, in front of the ACCC. And this is actually a great example of how the ACCC can work very effectively, where businesses don't even have to get to court, but it can be a commercial decision and a really practical one to make consent orders and declarations in order to minimise that loss as much as you can, and have the matter concluded and save yourself those legal costs. But it's it's an incredible space. It
is, and let me just pick up on a question we had. And this indemnities as well falls into this. So when we're thinking of indemnifying one party and not the other,
so there's liability provisions and
right.
really bringing the balance on one side, not the other. Yeah, interesting. So let's talk for a second about what businesses can do, because I think when we look at unfair contract terms, we often talk about what you can't do, and then it becomes, well, what can I put in my contract? There are some defences, if you will, or ways to mitigate the risks around unfair contract laws. The first one is going to be, the threshold question of, do unfair contract laws apply? Are you a small business? Is the contract a standard form contract? And then we're looking at that contract as a whole. The circumstances, is it unfair in that entire scenario? What about reasonably necessary to protect legitimate business interests? Because businesses do have rights to protect and interests that we just need to be able to justify and defend.
And it's a fine balance. It is, it's identifying, and when we do this on a daily basis, you go through and you're identifying what the purpose of this clause or this term is.
Why do we need that protection?
Why is it in there, and what interest is it protecting? That's a really big one when legal teams are going through these contracts to figure out, are these drafted to the circumstances that will be used?
It's going to become a little bit less of what would we like to have in our contracts with what can we have in our contracts so that it's fair and reasonable, particularly in that standard form space. Also, that no detriment, if there's no detriment or financial issue arising from the term, and that significant imbalance we talked about before. But transparency, I think, is an interesting one as well, because I think one of the things we often do operationally, I know in-house legal teams do this, management do this, where they try and bring key terms to customers' attention so that they don't get mad about it later when they have to rely on it. So they're entering into things with informed consent. And we talk about transparency around plain language, it being presented clearly, but a transparent term can still be unfair.
Still can be, and it is one of the legislative factors to take into consideration if something is clear and presented in plain language. And that goes to, it also goes to, people in the business understanding what the contract does that they are presenting to the other side. It is, it's surprising how many times we get given a contract by someone and they go, I don't actually know what this is saying, what this means.
The lawyers prepared it.
The lawyers prepared it, and they said that this is the one to go with. That this is going to be a real issue if we're presenting something which is unfair and has a really onerous legal outcome. It needs to be transparent and in plain language.
Yeah. It's a tough one, I have to say, I think, for businesses to navigate because it is so grey. We wanted to also just mention this other change that snuck through, I think, in 2021. I mean, we noticed as lawyers, but I think a lot of businesses didn't realise that the Australian consumer law also expanded. A lot of businesses, I think, have previously ignored Australian consumer law a bit, or they were either in that space or they weren't. One of the thresholds under the Australian consumer law is around that goods and services value. So it used to be under $40,000 you were covered because you were dealing in those consumer goods or services space. That increased in 2021, back in July, up to $100,000. So again, some of these arrangements for services, for goods, is now going to be covered, I think, more than before.
Well, and I mean, and this is beyond just unfair contract terms.
Yes.
I mean, this is picking up all the consumer protections, the consumer guarantees that are given to consumers when there is the purchase of goods and services.
Quality, fitness for purpose.
Exactly. And it gives businesses significant remedies against other businesses.
Yes.
In when you're talking about a contract that may have been negotiated.
Yeah.
These are statutory guarantees which you can't contract out of.
So, and that's amazing, right? When you think about consumer guarantees and their purpose being applied in a business context, which is, it's a really big change, I think, that we wanted to draw people's attention to, because I think it did get a little bit missed. So on that note, we talked about the penalties being increased across both unfair contract laws and the competition and consumer laws. I wanted to touch briefly on what that's going to apply to, because I think I know a lot of businesses are so busy doing business and with their day-to-day operations that some of these concepts under the competition consumer law does get forgotten a little bit. We're busy negotiating commercial deals, but without turning our mind to this. And I think with those new penalties coming in, looking at some of those concepts up on the slide, if you're not thinking about that in a $50 million fine context, we really should be now around your operations and how your staff trained in this and how are they protecting your business from some of these issues like misleading and deceptive conduct, or the Australian consumer law breaches, or unconscionable conduct, things like misuse of market power, cartel conduct.
And these aren't just these, you mentioned cartel conduct, and these aren't just the big misleading, deceptive, the ones where you think, trade practices law, we can't, all these are kind of traditional ones. We're talking about exclusive dealing.
Yeah.
We're talking about market allocation.
Absolutely.
Areas that
competitors get together in perhaps that small business space, and
they make an agreement to, it works out in a favour to go attack these markets.
Right.
It's these, and this is all captured in these much higher penalties. So it's really worth taking the opportunity now when we're looking at contracts, we're looking at business processes, and we're looking at the way that the entire organisation is addressing these issues, because this is no longer, a question of whether it was in the previous legislation, but now with these increased penalties, I mean, it just has to be front and centre.
Yeah, absolutely, particularly for individuals, because you might remember on the first slide, we had those individual penalties going up from 500,000 to 2.5 million. Just a reminder, under the competition and consumer law, there's a provision that allows actions to be brought against individuals as an accessory involved in a contravention of the Act. So this isn't just directors, this is a manager, this is a staff member who was involved in cartel conduct or misleading and deceptive conduct, as the case might be. So I think that's definitely got to be front of mind for businesses. All right. Do we want to take a couple of questions? There's a couple of questions coming through. We did just sort of fly through the content. Contract laws. So one of the questions is, does the unfair contract laws apply to business? Yes. Absolutely. So this is the whole thing about unfair contract laws that I think businesses don't even realise, is that the current laws apply to business-to-business contracts. They're going to apply to more business-to-business contracts because of those expanded new regulation that's going to come in, where you have that up to 100 employees, that higher $10 million turnover concept.
Well, and before, I mean, especially large businesses that had these contracts, there was that dollar threshold that really meant we were dealing with smaller business to business,
and smaller value.
Smaller value. We had $300,000, and I mean, it's a significant contract. However, for your medium and larger sized businesses, that's gonna really cut down on the impact. That threshold's gone. So we're just to fall into this as a business. Only one of the two parties needs to have employees of less than 100 people.
Yeah.
If that's the case, or less than $10 million in turnover. Now, if that's the case, these unfair contract terms do apply. So that could be, a large, a huge national organisation dealing with a local tradie. I mean, the unfair contract terms are going to apply.
Yeah, and look, I think that's a really interesting point as well when you think about how this could be used, but also how you could potentially use this as a small business to protect yourself as part of those negotiations. So as much as this is going to affect your contracts, you can also be thinking about how you might protect yourself, defend yourself in the event of a breach. Are the terms that are being applied to your contracts enforceable if you are a small business? And
I think this point goes to the real concern that I have as as someone who's assisting businesses, and it's adding to that cost for every contract now. If you're either trying to take it away from a standard form template, saying that there's room for negotiation, or potentially pulling it out to say that this isn't standard form, or you're having to make an assessment as to whether it falls in on whether you've got any of those other defences. And if you're having to do that with every contract, I mean, it's a real big question as to how business is going to be able to manage this. I mean, that's what we do, and that's what we help businesses with. But it's a big step in that in the impact of these new laws.
And I think it'll put a lot of pressure on that contract management process as well, where people are trying to do that in-house, trying to use those standard form contracts and negotiate them, or as the case might be, not negotiate them. And I think that's definitely going to change. We might just take one more question before we move on to data breach prevention and response. One of the ones that came through before this webinar, so thank you for sending your questions through. We did get a lot. We can't talk about all of them, but some of them are very specific, so please do feel free to get in touch if we don't get time to go through all of them at the end, but we'll do our best. One of them was a question around what is the best approach for bringing old contracts that are still in place into compliance with these latest unfair contract changes?
So I think, to reiterate, this will only apply to new contracts, variations or renewals. But
the expanded regime.
The expanded regime.
Yeah.
So if you're trying to get, or you want to make sure your existing contracts are compliant, I mean, it's really figuring out what you do have in place, and particularly standard form contracts will often have those automatic renewals. So it's taking a look at how those contracts are being renewed and the timing if you need to terminate the contract because it won't comply.
And if you need to, factor that in, I think, to your timing. So if you know a renewal date's coming up, maybe instead of letting that roll over, you take the opportunity to renegotiate that contract. So it's no longer an unfair contract if you are a little bit concerned that it might have fallen within the current regime even.
That's right. Yeah. I mean, and so taking a look at those automatic renewals, if any changes are happening to the contract, it's really going to have to be a case-by-case basis for each business. So it's not an easy answer to that question. It's really it's a difficult one for businesses to manage, and we can always.
We obviously don't want to unilaterally terminate or vary contracts on people. We want to be compliant about how we're contracting in a business-to-business contract. So there's some great questions coming through. We will take some time at the end to go through those. Let's jump into cyber, because I think this is a hot topic. I mean, you'd have to be living under a rock not to have seen the media and the businesses that are in the news. And look, I wanted to kick off by saying the main message out of today is this could happen to any business, literally you. It could be your business. Sometimes I think it's just unlucky that these people happen to have their name up in lights. Obviously, there are things you can do to help prevent, to help make sure that your security systems are in place, that you're complying with the privacy laws in Australia, but it's certainly a tough area at the moment, and businesses are really talking about it. And one of the reasons we wanted to do this webinar is because it's everywhere, right? It's the buzzword on board agendas, it's in the media, but no one seems to know what to actually do in practice. So that's
and
some
it's
of the
not
things.
only businesses. I mean, I'm thinking about it as a
consumer,
and we'll get to that. But I mean, I'm thinking about it as a consumer, and if I'm thinking about it, I mean, everyone is.
Absolutely.
It is a really hot topic, and it's a difficult one. So we're going to talk about some strategies
and look, some of those reputational damages as well. There's the regulatory side. So we're the regulator for privacy in Australia. We're talking about the Office of the Australian Information Commissioner is investigating a number of these. They're also fast-tracking some legislation, which we're going to talk about, some reforms in the Privacy Act space.
Increased penalties as well.
Yeah, so again, there's a theme today of all of these penalties that are going to affect businesses around these data leaks. And one of the things that they've come out and said is it's obvious that the laws in Australia are inadequate to incentivise businesses to do this, and that's why they're bringing this sort of fast track so that they have bigger sticks, I suppose, as regulators to play with. Yeah,
and I mean, let's jump into some of that.
Yeah, and look, and before we do, I just wanted to touch on the MyDeal breach from Woolworths, because I think everyone's heard about Medibank, everyone's heard about Optus. We're not going to rehash what happened there. But MyDeal was an interesting one because Woolworths had just bought MyDeal. So they'd done this transaction in September, and by October, so less than a month, they had a data breach and they were in a headline.
And I mean, that just screams due diligence to me, and understanding, those data questions and that investigation that happens at the start of a transaction is becoming just so important, understanding the business that...
Because you're taking on someone's risk profile, you're taking on their
is.
systems, their data. Did they have the relevant consents from customers to obtain and hold that data?
What policies look like? What do their internal and external facing policies, data breach policies, privacy policies?
And we know those customer lists are so valuable. So people are acquiring businesses because of their customer list, because of their data privacy.
Often that's one of the
these
days, it's a key asset of a business. So understanding the risk profile that that asset is presenting to you as the purchasing entity is a huge deal now.
Absolutely. So let's start with the regulator focus, because I think when you start with what the regulator is focusing on, what they're saying, it gives you a real sense as a business on what you should be doing or what you should not be doing. And one of the things that has come out of the Optus investigation and where the regulator is focusing on is whether the Optus companies took reasonable steps to protect the personal information from misuse, interference, loss, unauthorized access, etc. And also whether that information that they collected was retained. Was it necessary to carry out their business? Did they need to have it? Did they need to have all of it? Did they need to keep it? And I think that's a really key question. How long are you holding data is something that every business should be asking
And I'm going to
themselves.
say it now and I'll say it later. What data are you holding and why? I mean, that's just, this is one of the key pieces that I think we're talking about bigger penalties, we're talking about regulators, but businesses understanding why they're holding data is just so important,
right?
For various reasons that we'll get to. But I think, that question is a key one, which is going to run throughout the slides today.
Yeah, and one of the things that Commissioner Falk from the Australian Information Privacy Commissioner said was, one of the things that these big corporation data leaks tell us is that it brings to the fore the importance of organisations securing that information, thinking about whether it needs to be collected and retained in the first place, and that message there in the middle. So only collect necessary personal information and delete it when it is no longer required. Now, there's obviously regulatory overlay depending on what industry, what sector you're in.
Contractual as well.
Contractual obligations to retain certain data. So you have to be careful there. But I think there's this ease, because we have all this cloud storage these days, to just keep everything.
And I mean, it is an asset. It can often be an asset from a marketing perspective. It can be an asset for a business in the way that they engage with their customers. But that could just end up being, maybe you need to retain an email address. But this, going and holding dates of birth, personal addresses, health records.
Yeah.
All of this is, query what the reasons for holding that and the consent that was obtained when you actually obtained that information.
Yeah, absolutely. And then, of course, that next step, which we're going to walk you through around what to do in the event of a data breach and being prepared, I think, for organisations in the knowledge that this could very easily happen to you. What's your data breach response plan? I
mean, and what I will say before we go through more of this could happen to any business, even if they've done it. Like this
they could do all the right things.
The way things are going. I mean, this is a risk that is inevitable, that it's going to happen to businesses that have done all best practice. Yeah. So that's why we concentrate so much on the response plan.
Yeah.
Because it's not only prevention, when prevention is incredibly important, but it's understanding what to do when we get to that point of it happening.
And it's got to be both. And I think when you do get to that response plan and that regulator reporting side, the fact that you have prepared and you have done everything that you can possibly do does put you in a better position to defend yourself. And it's the first thing we look at when we're defending clients in that data breach context. And this is the other reason, I think, why we say this can so easily happen to everyone. Because as much as we hear in the news these criminal attacks, this ransomware, phishing, these sophisticated cyber criminals who are getting...
You get the picture of someone in a dark room and kind of, behind a monitor.
Sending out clever but slightly dodgy emails to you that, it's like, was that really from you, Kurt? Clearly not.
Yes.
Then we look at the actual statistics, and this is the last 6-month report from the Office of the Australian Information Commission, and this is a recurring theme. So every 6 months they put out this report, and the stats are always really similar. A huge number of the data breaches reported are caused by human error, because people are our first line of defence. They're our weakest link sometimes if they're not trained properly and are not aware of phishing and other cybersecurity risks.
Misaddressed emails.
Right.
Leaving the door open, something left on a bus. These are the human errors that are most common when we're dealing with data breaches.
Clicked on the dodgy link, sent it to the wrong email address, and you can see there's some top causes of human error breaches, emailing to the wrong email recipient. that's a data breach if it contains personal information. And I think, most people have done that. Unintended release or publication, or mailing things to the wrong recipient, getting the address wrong. And, you think of that in an employer context, how many times have we had employees leave and they might have sort of taken the customer list on the way out. That's a data breach, and you're going to have to report that potentially to your customers, to the regulator.
It's not only a restraint issue. That's a data risk and security issue. It's a regulator issue. That's right.
So I think we talked about the human firewall being really important around the training piece. Obviously, that increases with working from home, human error, and that financial and reputational impact is huge.
And I think this is just kind of a final point. I think this isn't only about the regulator impact. This other, there was an article, and this is 2 days ago, where the AFI had done some survey to say that more than 3/4 of people aren't sharing information with a service provider if they don't have to, and they're potentially you're losing business.
They're questioning
why
do you need that?
Why do I need to register?
Yeah.
Why do I need to register to obtain a product that I could go and install for?
Why does the travel agent need a copy of my passport?
Why
do they really need it? Do they just need the number?
Exactly. And I think as we get further down and see more of this happening in the news, we're not being really mindful of the reasons for why we're taking this information, then consumers and potential customers are going to question that for us and potentially go somewhere else.
Yeah, they're going to vote with their feet. And
data shy is what
I love that data shy terminology, where that is the new consumer. It is, that young person who's like, well, no, I'm not giving you my private information. And do you need it?
Yeah,
your business needs.
And contracts as well, of course. I mean, we've got tender requirements. A lot of, particularly government contracts, will the right fit for risk and all this, very specific ISO requirements and accreditation. But often that will need to go, that's an upstream requirement, but it will need to be applied downstream to your downstream contracts. So there's a lot of different things to consider when we're looking at these data privacy issues.
Yeah, and I think that's a key point as well, where we are seeing that's the first time. I know these reforms are coming through, which are going to have that bigger penalty effect, which I think will make businesses have to pay more attention to their cybersecurity and privacy protection models. But these contractual requirements, they exist already. We're reviewing them all the time. If you do a government tender contract, or even the supply chains, whether you're upstream or downstream. So if you're upstream, you're thinking, can I comply with those obligations? Can I warrant that I have all this security in place, and that, yes, I'll provide you with information if I do have a data breach? Do I want to provide you with information if I've just suspected a data breach? Do we just want to notify about
these things sit at the back
actual?
of the contracts, where they're kind of the standard form at the end, and we're really having to focus on that.
Yeah,
these are becoming key battlegrounds from a contractual perspective around understanding businesses understanding what they are agreeing to.
Well, and the flip side as well, I think, from a supply chain, if you're getting IT services, whether it's a website, a software, an app design, maybe you're getting someone in as a managed service offering to do your IT support services or your maintenance, you're giving them the keys to your company.
Yeah.
And my question is, what's in that contract? They just made that app for you, or they're playing with your systems or your software. What security obligations are you putting on with them? And we work with both sides, with the IT service providers, but also with businesses who are procuring IT services. And some of them are missing out on work because maybe they don't have ISO accreditation. Maybe their contracts are so lacking in the fact that a business wants you to say, I'm a trustworthy IT service provider and I stand behind my security standards.
Yeah.
Interesting. Let's talk penalties again. So this is in the privacy space now. There's a lot of options obviously available to the regulator already around enforcement of privacy, but it hasn't had really big teeth yet in Australia, in my view, in terms of penalty regimes and enforcement. What this new bill that's been fast-tracked as a result of some of these big corporate hacks is going to increase those penalties. So similar to what we were talking about, in alignment with that competition
huge
consumer
increase.
space.
We're up to 50 million again.
Yeah, and 2.5 for an individual. Plus, they're going to have some greater enforcement powers. So enforcement powers to resolve breaches, to get more information from you about what happened in that breach, to share information about those data breaches to help protect customers. So they're really taking, I think, a proactive approach to resolving data breaches in dealing with those issues.
And I think some of those time frames are compressed as well, and some of the ability to take your time. The commissioner is going to have real strong powers to just get information or request information, and it need to be provided in a very quick time frame. So, and that leads us, I mean, we're going to get there, but into how
what you should be doing.
What you should be doing. So you're set up to be in a position to respond to those and to comply with those tight time frame requirements of the Privacy Act.
Definitely, because it's a tough area if you do have a data breach, and it is very stressful, I think, for businesses where they're still in those early days trying to figure out what on earth happened. I had a great analogy the other day, which was around cyber breaches and data security breaches being like not just a burglary of a house, it's like having a theft happen in a whole suburb. You've got to figure out which houses have been affected, what's been taken, what was the cause, where did it come from, how do we make sure everything's secure again. So it's a really crazy time, I think, for businesses. But let's start with some of the basics around what you should be doing and what you need to know about the privacy laws in this space.
So this is the legislation. This is where we're kind of the baseline where we're starting from a legal responsibility perspective.
So this is Australian Privacy Principle 11, which tells businesses what you have to do. So if you're covered by the Privacy Act, you have to take reasonable steps to protect personal information from misuse, interference, loss. Now, you might remember that's one of the things that Optus is being investigated for. Plus, this is middle one's what everyone forgets, data retention. You have to take reasonable steps to destroy or de-identify personal information once it's no longer needed for the relevant purpose.
So when we talk about relevant purpose, we're talking about the purpose for which the data was originally obtained,
right?
And the consent from the data subject, and that will usually be set out in a privacy policy.
Yeah, at the time of
collection notice. Those are really important documents that are often overlooked.
Yeah.
But these come into these responsibilities around how you're dealing with that data. It's not just when you obtain it, it's ensuring that when you're done with it, you are deleting it. And it's a legal responsibility, but as I say, it's a risk management as well.
Definitely.
If you're not holding data that you don't need, you're naturally decreasing your risk of having that. If there is a data breach, the harm that goes with that. If you're not holding passport numbers, if you're not holding dates of birth, then your potential risk profile is lowered.
Definitely. And there's cases on that, of course, where those data breaches were more harmful because they kept data for years and years and years beyond what they really needed to. And then, of course, when we're talking about this space, we talk about reasonable steps a lot. And I know there's a lot of businesses of different sizes watching today, and this will depend on the circumstances, including the size and resources of the entity, the amount and sensitivity of the information. So obviously where it's really sensitive data, things like health records, personal information, vaccination status, of course, is a health area, and the time and cost as well. And just because we say, oh, I'm a small business, it costs money to have these protections, doesn't mean you get out of it, right?
Well, I mean, and just because you're a small, you say, oh, I might not be captured by the Privacy Act because there's certain thresholds. I mean, if you're collecting any of that sensitive information or you're collecting health information, your
visa status,
this is all a subcategory of what sensitive information, health information. There's responsibilities in respect of this that are going to apply to small businesses anyway, and do apply to small businesses. So it's worth just picking that up.
Absolutely. So down at the bottom of that slide, of course, are a few little flags of certain things that you can be doing to tick this box, so to speak. Obviously, we want you to go beyond just tick box compliance, but governance and training. What do you have in place? What are you doing with your staff? And it doesn't matter what size business you are. You just need to be taking those reasonable steps to do what you can. That human firewall. What ICT security do you have? Have you got two-factor authentication? What are your internal procedures? Do you have a data breach strategy and response plan? What are your physical security measures around, ensuring that your data is secure? That destruction, de-identification piece, and of course, your contracts and arrangements with third-party providers. All right, I want to go through what to do in the data breach space. So breaking it down to the basic essential steps. The first thing we want you to do if you have a data breach is, of course, contain it. So we want to stop the bleeding. We want to make sure that the risk doesn't become even greater. So, figuring out what happened, making it stop as quickly as you can. And then we're going to need to assess it. So one of the things we need to figure out, and I'll talk more about what this is it an eligible data breach? You know, have you established legal professional privilege over an internal investigation? Are you getting some advice on the evaluation of that breach? Because that's going to determine how we remediate it and also if we need to report to a regulator.
And this is all going to be, and that's a key point here. This is all information that's going to have to be provided. If we are in that eligible data breach territory, I mean, this is stuff that's going to have to be reported to the commissioner. So we need to be mindful that we're on show here when this occurs, and how the response is managed becomes something that needs to be put forward and demonstrated to the commission if it becomes an investigation.
And of course, that notification, there are specific requirements in terms of content, and we'll talk a bit more about that. But, you know, is it required to be notified? Because we don't really want to have to tell the world that we've had a data breach if it's not an eligible data breach. And that's an interesting space to talk about from a best practice perspective and get some advice on. And then, of course, prevention for future breaches. We want to be learning. If it happens to you, you learn from your mistakes, but you can also learn from other people's. So very quickly on eligible data breaches and what that will be. Usually it is under the Privacy Act. If an eligible data breach will be where there is unauthorised access, disclosure or loss of personal information, and that access, disclosure or loss is likely to result in serious harm. Now, sometimes you can remediate that harm. So say, for example, you send the wrong email, an email to me by mistake, and whoops, that's a data breach. It's got personal information. Maybe it has health records in there. You know, I don't know what's in there. It could have valuable customer lists. But you say to me, and you know, hopefully you've got legal privilege, please delete that email. I confirm that it's been deleted, and because I'm a lawyer, privilege will apply. And so, of course, you've potentially been able to remediate that likely risk of serious harm.
And I mean, the serious harm test is, you know, we don't have time to go through it. Of course, it is set out in the legislation, so we're dealing with a kind of statutory process here to identify whether the potential harm resulting from this is serious harm. And it's a really, you know, it gets quite technical, and it is a difficult process to understand and make those assessments as to serious harm. And, you know, you need to be walked through that often.
And depending on, again, what type of data, is it sensitive? What was the nature of the harm? And we saw that in things like the Medibank breach and the Optus breach, that risk of identity theft, the risk of health records being released, and some have been released, which has been awful to watch in the media. And then, of course, there's a process. So this is a legislative process. So you can't just stick your head in the sand and say, oh, goodness, I just have to focus on my business and getting back up and running. You need to be going through the process, both in terms of that investigation, there's some time requirements, figuring out if it's eligible data breach, preparing that statement. So as you said, figuring out what happened, how we can communicate that openly and transparency, but also by minimising our reputational risks about how you've addressed it. And being accurate about that, and providing a copy of that statement then to the regulator and also to the affected individuals. But being, you know, careful and strategic, I suppose, while also transparent about what you put in those notices, because we want to be minimising that serious harm to your potential customers and your employees. Sometimes it's employee data, of course, that's affected. And so we need to be very careful about those statements, but also that they meet those legislative tests for content. And I think that brings us to prevention.
Got 10 minutes, so we should...
We'll whiz through this one, then we're going to go to questions. One of the things about prevention, I think, in this space is that it goes hand in hand with response, because as soon as a data breach happens, the first thing we do as well is, while all of this is happening and we're reporting, is we're looking at what we can do to prevent this in the future, because it's a great position to be in. You're responding to a regulator to say, we've had this happen, we've remediated the issue, we've fixed it, it won't happen again, and we're doing all of these other things to put our business in a better position so it never happens again.
Yeah, it's a really powerful thing to be able to present those learnings from what's occurred, and that's really something that the Commission does look at. You know, it's one of their questions that they ask in every case. What have you done to improve your systems and improve your processes, improve your training to address how this occurred. So, and
that training piece, that staff, that human firewall, again, it's such a common theme in this space. And even looking at the incredible amount of resources that are out of there, I wanted to mention the AICD cybersecurity governance principles that they've just released recently. If you're a business, and it doesn't matter if you're a small business or a big business, these sort of concepts apply to everybody. If you're looking at that slide and thinking, gosh, I don't tick many or any of those boxes, I'd be really raising some red flags about how secure your organisation is, how compliant you are. If you're ever investigated by a regulator and you have that issue come up, do you have clear internal roles and responsibilities? Have you identified those key digital assets and data? And what about those third-party supplier risks? Like, what IT contracts have you got in place? What protection do you have, or indemnities, right? If I've got a third-party IT provider, then I want them to indemnify me, because we've seen that as well, where third-party IT providers are targeted by hackers because they know they hold lots of data, particularly, online servers and things. And then, we've had a client with that issue recently who it wasn't them that had the data breach, but it was their IT provider. And so suddenly they're caught up in it and having to notify.
What does your contract say about that? Often very little.
Yep.
If they're standard form contracts written by the cloud services provider, you're really not having that protection that you need to be able to demonstrate, and to show what's being done about these really important issues.
And look, and embedding cyber in risk management, I think people forget that cyber is just another risk facing business. It's as common as having locks on your doors and work health and safety management plans. If you think about, 10 years ago, maybe work health and safety wasn't so common and normal to have protections about.
At a board level, this is a key governance thing now, just up there with WHS.
Well, and all businesses have data online now, pretty much. So I think that's an interesting concept to get everybody thinking about, that this is just another new normal risk management issue to manage, and how we promote that culture of cyber resilience in the organisation is really important at a staff level all the way through to directors. And incentivising that and proactively preparing for these cybersecurity incidents and testing your staff on it. There's some great stories that are out there around how some businesses have tested their cybersecurity defences, and
simulations can be real,
the white hats, right?
Real eye opener as to some gaps and where improvements need to be made.
Totally. And unfortunately, those white hat kind of companies who come in and test your defences, and everyone's so nice, they let them in the front door, they scan them up in the lift. Sorry, I forgot my pass, and I just am here for the day from another office, and can I use the computer? And someone makes him a coffee while he hacks John's computer. So, I think that testing of staff as well is really important.
So I've got some, just a brief checklist here, and we've talked a lot about these. But that cyber health check and compliance audit, where we're looking at, your current processes in place, looking at documents, your privacy policies, your collection notices,
absolutely,
data breach response plans, that kind of legal compliance audit.
That privacy by design, I think, when we're looking at a business and that data flow of the life cycle of data, from where you collect it, how you use it, how you disclose it, how you transfer it, how long you retain it, and then eventually how you destroy it. And of course, documentation is key. This can be the bit that makes or breaks you from the regulator. Of course, policies are no good if you don't follow them. And I think those response plans as well, we've seen there's two types of businesses, I think, in terms of cyber incident response: the ones that are prepared and the ones that kind of run around like crazy, trying to find a quick, I need an expert in IT and cyber response, and I need a lawyer to help me with this. And that's not what you want to be doing when you're trying to respond promptly. So again, having that team on speed dial, sometimes PR as well, is another person on your dream team you need to have in your data response plan, so you've got that on speed dial. And
we've spoken about training's a big deal. That human firewall, and then your agreements, we've mentioned that our data breach responsibilities and the contractual protections you have from your downstream and upstream suppliers, and insurance. Of course, always lots of changes in the insurance space, which obviously is a broker question, but we're just seeing and how those are captured in your contracts.
Yeah, for sure. And look, I know we haven't had time today to talk about director liability in the cyberspace, but that's another hot topic, I think, in the boardroom at the moment, and all those businesses who think about that duty of care and diligence. And I think these days you can't say you've complied with your director duties if you're not thinking about cyber, because how are you being diligent and looking after your organisation? I want to finish on some proactive things, because I think it's really important to finish up on, yes, there's lots of penalties coming into play. These laws are expanding. It's definitely getting more regulated and harder to do businesses, I think, in that commercial space. But now, even though we have 12 months for the new unfair contract laws don't forget those unfair contract laws apply now. So it's a great time, particularly as you're entering into new contracts or preparing to enter into new contracts, renewals, to be looking at your contractual documents already.
Yeah, that's right. I mean, everyone knows how long it takes to get business input.
Once you get contracts approved, right, up the management chain.
Get business input on kind of standard form contracts within a business. We need to be starting these processes now to be able to get to be compliant. Right? We and understanding the reasons for inclusion of a lot of these terms. We'll need to have really clear justifications for a lot of contractual terms when we're dealing in that fewer than 100 people and employers.
And I think we've covered off the cyber action points on the previous slide, but we did talk a little bit about training, because obviously that's an important thing to be able to say to regulators, that you're doing everything that you can. But also, if you're managing contracts in-house, if you have people on the front lines, do reach out to us. We do run business contracts training. The next one's on the 25th of November, so we will talk through those unfair contract concepts in a little bit more detail, a little bit on the competition consumer, but we're going to roll a specific competition and consumer law training out in 2023, or we can always do something bespoke. I want to do a very quick fast fire question. But we do have a couple coming through as well, so I'm sorry if we are going to run out of time, but feel free to reach out to us directly. Kurt, 30 words or less. Different rules. Are there different rules for small business regarding cyber attacks?
Well, yeah, we mentioned a little bit about that in terms of the Privacy Act does apply. It does have a threshold for if you're an APP entity. Now, so if you fall below that threshold, there are slightly different rules, but it really will be a business by business consideration, because if that's the general rule, but there are specific areas. If you're collecting particular sensitive information, then that will still apply. Your responsibilities on the Privacy Act will depend on the information.
Yeah.
So it's a depends question.
Well, and I think a lot of people kind of say, I'm a small business, I'm exempt from the Privacy Act.
Not necessarily.
That's so rare, and there are so many exceptions to the exception that people end up getting caught by, because we do collect so much data these days, including about our employees.
Especially in employment context.
Well, that leads me to our next question, because we've got a couple coming through around employee personal information. What should we be holding, particularly around forms of ID and some of that sensitive personal information, perhaps health information that businesses, employers, HR are collecting? What should they be doing around that? Should they be collecting it? How long should they be keeping it for?
Good question.
It's a great question. Do you want me to answer it?
Yes.
Okay. So one of the things that I think people forget about privacy laws is they say, oh, there's an employee record exemption, don't have to worry about it. Employee records is a very limited concept, and these days you find HR files include all sorts of things around vaccination, visa status, copies of visas, copies of passports, rights to work in Australia. So I think you have to be really careful about what you're collecting, why you need it, how long do you have to keep it for? Is there a better way to do it? We talked the other day about visas, right? Visas. Do you need to keep that on file? Do you just need to cite it? There are other ways also to go about
checking and really looking at your legislative responsibilities under the Fair Work Act and finding out what data is actually required, and then how you're managing what data you do need to. So it is a...
And how are you keeping it secure? Like, if you can do it a different way that stops you from having to keep that, like those online checks for visa status and things like that, then perhaps that's the better way to go. I'm wondering if we then finished on the data retention issue. I think we answered a couple of the unfair contracts law questions previously. Let's finish with that one around data retention. How much data should companies collect, and how long should they keep it for? I think this one's how long is a piece of string, right? And every industry will be different.
We've kind of run out of time, but it really depends on a whole range of factors.
Yeah. Regulatory overlay, your contracts. What do your contracts say? What do your government contracts say about retaining data? What do you need to run your business? And what does your privacy policy say? So it's really that mishmash. Did you have a broad enough consent to have that, keep it, and continue using it?
So it is a how long is a piece of string, and come chat to us about it.
Absolutely. Thank you so much for joining us. We are going to wrap up on that note. If we didn't get to your question, please do feel free to reach out to us directly. Always happy to have a chat with businesses, particularly around these new legislative changes in unfair contracts, competition, consumer law, and cybersecurity and data privacy protection. Thanks for joining us.
Thanks very much.